All right. I'm amazed at how much the prosecutors are giving me a lot of diversion, a lot of the prosecutor secretaries. They're diverting my defense a lot, all because of the way that they do things is what they think is the proper and right way to do things. And it's not been my experience in other states to follow these procedures how these Wisconsin prosecutors follow them. I mean, in Bethany, Missouri, I got the evidence right away. Within a few days, I asked for it at my first court hearing. My first court hearing was within 24 hours. The evidence, it took a long time to get evidence. It took over a month to get evidence from Hayden, Colorado. Louisiana, that evidence it took about 2 weeks, and the only way that Prosecutor Benjamin would give it to me was right in front of the judge, right at the hearing. He just kept playing me off the whole time. There was another time I got evidence. Oh yeah. Kentucky was pretty quick for evidence. I asked discovery. We didn't even need to have a court hearing for the prosecutors to hand over evidence. But now with my 2 Wisconsin arrests, I got nothing. I got the police in Milwaukee wanting over $600 for their evidence, and I don't have a response yet in Outagamie County, but they probably want a lot of money too. It's Wisconsin, and the prosecutors, I have no idea who the prosecutors are. They're not offering the evidence. And I would argue that the case starts when it's put into the public arena. That's when everything is fair game. I can write motions because there's a case number. I don't care when the prosecutors see it or not, when we have to wait until the first court hearing. I bumped up that court hearing. It was supposed to be in September, and I had it bumped up to July 17th, which is the next week. So, did they expect me to just wait on evidence until September? That's months away. It's just like, you question if the evidence is still available at that time after all those months. You kind of, I think it says right in the statutes that you should submit a bill of particulars immediately after the arrest, and that's Wisconsin statutes. That's pretty much standard across the nation in every state anyway. You submit a bill of particulars quickly. But a discovery? Discovery is the first thing I want. But a lot of lawyers probably would rather just go with the bill of particulars and sidestep discovery, and then from the information in the bill of particulars submit a motion to dismiss, a motion to suppress evidence. A lot of them may just want to go right for motion to suppress evidence and just not even ask to see discovery. Just forget about discovery. But I want the discovery. I want to see what they have to say about me. Whatever they got. I collect evidence myself. I have cameras and I have my evidence, and I want to compare it to their evidence. This, going straight for the motion to dismiss is a little crazy, and it looks like in Wisconsin they'll punish you for going right for the motion to dismiss. They'll hold off giving discovery if you file for a motion to dismiss, and they want to talk about the motion to dismiss, and if they deny that, then you go into discovery. I don't want to overstep. I don't want to take put the cart before the horse. I think discovery is the first thing you do. Have a look at what they got. I don't want to go right into a motion to dismiss. I want to see what they got. So I'll take that time. But there's some blockages, and it says in the statute that the prosecutors are supposed to respond in a timely manner. Okay? But they're putting roadblocks in front of me. I don't need to declare pro se. That was a young secretary that told me that. And then the second secretary was like, oh, they don't look at it until your court case because it's forfeiture. I don't care when they look at it. If they don't look at it, well, I don't think the time starts. I don't think the gun goes off when the prosecutor looks at it. Okay? They could just my fate rests in the hands of the prosecutor like that. I have to be very vigilant of when they look at my case. And I mean, yeah, once again I bumped up the time to July 17th. That's when they have to look at my case. But the public has the ability to look at my case now already. I don't care about prosecutors. I want to be able to, I'm able to file motions, and I want to have time limits for their response on that immediately. And since there's no exact time limit, I asked ChatGPT, compare time limits for motions between civil and criminal. Civil, you got like 30 days or 45 days or something. But criminal, there's no time limit, just within a reasonable time. Well, with my experience in other states, that reasonable time is 14 days. So that sounds reasonable to me based on my experience in other states. Wisconsin hasn't defined a time. North Dakota has. They say 2 weeks, straight up. And that's probably what a lot of judges are deciding on. I mean, geez, why would you need 3 weeks? Why would you need a month? We want to get through this a little bit at a faster pace. So I filed that motion for discovery of evidence last week. And it's been a few days. I got to give them time. But I'm not sure if the time will come up on July 17th or not. I submitted today 3 more motions. A second motion for discovery, which is really focused on the forfeiture law, which I asked ChatGPT. I'm like, write me a discovery motion based on the forfeiture law. And I look at that and I'm like, wow, that's really cool. asking for the charts and graphs of the fee scheduling and all of that. I thought that was pretty cool. That's not a regular discovery. This isn't regular law in Wisconsin. They got forfeiture law. So I want to discover within the construct of the forfeiture law. So I wrote a second discovery with that in mind. I thought it looks cool. But we'll see what the judge thinks of it, what the prosecutor thinks of it. I want all communication that the prosecutor's made. It's said it's fair game in the forfeiture law, so I put that as part of my discovery request. It's not something I would have asked in any other state. It's different. Then I'm declaring that I'm pro se. I just kind of made a motion for that, just to make that clear. To have to go through some kind of a process in the court to properly be vetted as pro se is just ridiculous. They're forcing pro se. They don't even give you free lawyers for my type of crime. So what's there to vet? What's there for the judge to supervise? There's nothing. You're forced into pro se under the circumstances, especially if you can't afford a lawyer. If you can't afford a lawyer, well, then you're pro se. That's what it comes down to. And I don't need a court hearing for that. I've never needed a court hearing for that in other states. I have to wait for a court hearing. At least in Natchitoches, Louisiana, they weren't telling me that I had to wait until the court hearing to see the evidence because the judge has to make sure I'm going to be pro se. It looked more like a matter of the prosecutor was just being a big jerk about it. So I did declaration of pro se, I did bill of particulars, and then discovery. So the bill of particulars, I copied off of ChatGPT. I'm just like, write me a bill of particulars. Here's the law. Here's the dialogue that I had with the cop. And just write me a bill of particulars. And I look at it and I'm like, that's not bad. I'll take that. So I submitted those three. Probably took a good hour because I had to use my phone and write down on a blank pieces of paper everything that was the ChatGPT shared on my phone. So I was in that clerk of court's office for maybe an hour, just rewriting, because that's the only way they'll accept pleadings. It could be a discouragement for a lot of people. They might not have the time. I got the time. I always make time for cops when they want to do this to me. So I set aside time for this type of thing. So I wrote on 4 pages, three motions. It's like whatever. I'll write out the motions. I don't have to really think. I just have ChatGPT write the motion for me, and then I'll just copy it on a piece of paper. 'Cause, that's just the way the Wisconsin wants to do it. I can do that. It's no fun. It takes up a lot of extra time I don't care to do. And also, this courthouse does not have any Wi-Fi, so I had no access to ChatGPT anyway. I just had to go off of what I saved. I save while I'm at the library or Walmart, and then take it over to the courthouse and then paste. So I'm putting a lot of information into my phone because that's the primary device I'm bringing in. Leaving the tablets in the car, and just trying to learn the process, trying to work with the process. But I mean, once again, I believe that the time starts when the charge is made public. I mean, yeah, the public may not know to look up my name on CCAP, but it's still going to be there, and it's fair game once that's inputted. I don't need a hearing. That they want to argue that the time either starts when the prosecutor sees my case or when I have my first hearing. That's when the time starts. I don't think the time starts then. I think the time starts when it's made public. On the very moment it's made public, time starts. Start the timer for motions and all the stuff that goes along with the back and forth up until the trial. So, I mean, the public sees it. A potential employer sees it. You know that they'll use it against me. It's put on the public. I have an open case. So, 2 open cases in Wisconsin, and the timer starts. And the timer is long past due for Milwaukee. I haven't heard from the prosecutor in weeks. I haven't heard the prosecutor at all. And I filed my discovery motion weeks ago. So that's something to bring up to with the judge and ask, when do they think is a reasonable time that the prosecutor responds? If my case has a case number, it's on. It's started. It's not when the prosecutor sees it. There's no statute for that. They're just making up extra rules, and people are blindly following those when the prosecutor sees it. Too many people have accepted that.